The Company Directors Disqualification Act 1986, CDDA 1986, provides a statutory mechanism for preventing unsuitable individuals from participating in company management. The primary objective of disqualification is to protect the public and the commercial community by excluding individuals whose conduct demonstrates that they are unfit to manage corporate affairs. In addition to statutory disqualification, the model articles generally provide that a director automatically vacates office upon becoming bankrupt, reflecting the importance of financial integrity in corporate management. Where a court issues a disqualification order, the individual is prohibited from being concerned, directly or indirectly, in the promotion, formation, or management of a company. The individual is also prevented from acting as a liquidator, receiver, or promoter during the period of disqualification. Unless otherwise specified, the maximum period of disqualification is 15 years, depending upon the seriousness of the misconduct. The principal grounds for disqualification include conviction for a serious offense connected with company management, persistent breaches of the Companies Act 2006, such as repeated failure to file statutory returns, and participation in fraudulent or wrongful trading. A director may also be disqualified where an investigation by the Department for Business and Trade concludes that the individual is unfit to be concerned in the management of a company. These provisions ensure that directors who repeatedly disregard legal obligations or misuse the corporate structure may be excluded from future corporate management. The consequences of acting in breach of a disqualification order are severe. Such conduct constitutes a criminal offense, punishable by fines and imprisonment. In addition, a disqualified individual who nevertheless participates in company management may become personally liable for the debts of the company incurred during that period. These sanctions reinforce the deterrent purpose of the legislation and protect creditors from irresponsible corporate management. Removal. Although directors are appointed to manage the company, shareholders retain the ultimate power to remove a director before the expiration of the director's term of office. This statutory right reflects the principle of shareholder supremacy in corporate governance and ensures that directors remain accountable to the members whose interests they serve. The removal procedure is governed by Section 168 CA-06 and requires the passing of an ordinary resolution at a general meeting. The process begins with the giving of special notice, requiring at least 28 days' notice of the proposed resolution to remove the director. Upon receiving the notice, the company must immediately send a copy to the director concerned, ensuring that the director has adequate opportunity to respond to the proposed removal. The company must then provide notice of the meeting to the director and to all members entitled to attend and vote. The director possesses important procedural rights designed to ensure fairness throughout the removal process. The director may require the company to circulate written representations to shareholders explaining the director's position. If there is insufficient time for circulation, the director may instead require that the representations be read aloud at the meeting. Furthermore, the director has the right to attend the meeting and address the members before the resolution is put to a vote. These procedural safeguards protect natural justice while preserving shareholders' ultimate authority to remove directors where confidence has been lost. Duties. The Companies Act 2006 codifies the general duties previously developed under common law and equity. While these statutory duties now govern directors' conduct, earlier judicial decisions continue to assist in interpreting their application under Section 170 CA-06. Collectively, these duties require directors to exercise their powers honestly, responsibly, and in the best interests of the company as a whole. The first duty is the duty to act within powers, Section 171, requiring directors to exercise powers only for the purposes for which they were conferred by the company's constitution. Directors must therefore comply with the Articles of Association and avoid using corporate powers for improper personal or strategic objectives. Under Section 172, directors owe a duty to promote the success of the company, acting in good faith for the benefit of the members as a whole. This duty requires directors to consider the long-term consequences of decisions, the interests of employees, suppliers, customers, and the company's reputation while pursuing sustainable corporate success. Directors must also exercise independent judgment, Section 173, and avoid allowing their discretion to be improperly influenced by third parties. The duty to exercise reasonable care, skill, and diligence, Section 174, combines both objective and subjective standards. Directors are expected to demonstrate the level of competence reasonably expected of a diligent person carrying out similar functions while also applying any additional knowledge or expertise they personally possess. In Re City Equitable Fire Insurance, 1925, the court recognized that directors may delegate appropriate functions to employees and rely upon them in the absence of suspicious circumstances, although directors remain responsible for exercising reasonable supervision. The remaining statutory duties are designed to prevent conflicts between personal interests and corporate responsibilities. Under Section 175, directors must avoid conflicts of interest. Section 176 prohibits directors from accepting benefits from third parties, while Section 177 requires directors to declare any interest in proposed transactions or arrangements involving the company. The decision in IDC v. Cooley, 1972, demonstrates that these fiduciary obligations may continue to apply even after an individual has ceased to hold office. Where directors breach their statutory duties, the duties are owed to the company rather than individual shareholders, as established in Percival v. Wright, 1902. Remedies may include compensation for losses suffered by the company, recovery of improperly obtained property, avoidance of contracts involving the director, injunctive relief to prevent anticipated breaches, and recovery of assets transferred to third parties acting otherwise than in good faith.